Good morning, Tribunal members. What a great honor to stand on the lands of the Algonquin Nation. This very country is named Canada. It's a gift of First Nations peoples to the land and to all Canadians. And it means village. But for far too long, there's been two villages in this great nation. One for all other children, and one for the First Nations children who have called this land home for thousands of years. This case, this moment, is for the children. Over the next coming weeks, there'll be lots of legal arguments. But the thing that's most important is that you decide this case for the children themselves, for what's best for them, not what's best for the caring society and not what's best for the government. Because if you decide what's best for the children, you'll make the best decision for us all. This is a case dedicated to children like Jordan River Anderson from the Norway House Cree Nation. A little baby born and just wanting to grow up someplace else than a hospital. He was born with complex medical needs and he was staying in hospital. And when just shortly after his second birthday, when doctors said he could go home, he would have gone home had he been a non-Aboriginal child. But because he was First Nations, and because our government failed to put the interests of a child ahead of their own, he remained in hospital for over 2 years unnecessarily, and sadly, tragically died there. This case is for his father, Ernest Anderson, who after enduring the grief of the loss of his son, rallied his family and his nation and his community members to say, please don't let this happen to another child anywhere in the country, and we knew it was. Because in a study that the respondent commissioned, we found 393 other children being told, no, hold on, you don't get that service, or you get less, or you have to wait longer just because they're a First Nations child. And as the evidence will show, the government has done everything but honor the legacy of that child, even though they so directly contributed to the derision of his life. This moment is dedicated to the children, the ones separated from their families and placed in residential schools. And as we heard last week, thousands of them never came home. And to the thousands who are still searching for their childhoods that were lost there. And to the parents who grew up in First Nations communities all over this country where there were no children because the government of Canada had taken them away. Imagine living in a community where there are no children. This case is for all the children who are in foster care right now and the ones who grew up there. It's a day for anyone who believes that a child should grow up in their family home. It's a time when baby books fill up with the memories and the loving notes of all those who know that child and know how special and sacred they are. And it's a place where we form the stories that we'll tell our own children when they ask, what was it like when you grew up? This basic and important part of being a human being is something too many First Nations children have been denied by the Government of Canada. First in residential schools and now through the compound hardship of flawed and inequitable child and family services. Because growing up in foster care is hard. I think I'm one of the few in this room who has seen that firsthand, who has removed children from their families. Most of us as adults, we get nervous if we're even billeted out to a stranger during a sporting event. But imagine that you're 7 years old, that you're removed from your family and the only place that you knew, and you don't even know where you're going to sleep tonight. The social worker, as good and great as they try to work, they're so strained with resources, they may not even have an answer. I've seen so many children as I drive them back to the office because I have not a foster home to go to, that they're crying in the back seat and I cannot even turn around to comfort them. I don't know when they'll be going home. And I don't know if what I have to provide them is any better. The residential schools and the mass removals of children in the 60s, called the 60s scoop, it should have taught us all, as the Prime Minister had apologized for in 2008, that the removal of children unnecessarily from their families is something to be stopped. Because too many First Nations children have grown up not knowing the great traditions of their people, not knowing their languages and their cultures. For far too many First Nations children, their clearest memory of childhood is the day that they were taken away. The number of First Nations children entering child welfare care between 1995 and 2001 increased a staggering 71.5%. Now that sounds like a big number, but when I hear it, I think of only the little kids that those things represent. You see, together, it meant that they had spent over 2 million nights away from their families, away from their teddy bears, away from their language, and away from their culture. It was February 27, 2007, and we filed this case. I felt sad that we had to bring a case against the government of Canada to get them to treat First Nations children equitably. I walked through the hallway and I could hear the echo of my heels with the silence around me. And as I walked out onto Parliament Hill in a beautiful blue day, there was nobody there. I could have believed in that moment the Canadians didn't care, or maybe they thought the First Nations children deserved less. But I know that not to be true. You see, I believe in the fundamental goodness of people. And I knew that if they understood this inequality, if they understood there were solutions, they would absolutely work to make sure that this never happens again. There are people in this room from as far away as the United States and British Columbia who have come here to watch what children's future is going to be like. People are learning and they're listening. Tribunal members, in conclusion, I am the first witness, but I am not the first voice. There are thousands who have come before me who have tried to call attention to the inequalities that First Nations children experience, both within the government and outside of it. The time for talking is over. The time for justice for children is now. Whatever the government of Canada's arguments be, let they call us up to be a great country. And please, whatever you argue, make sure that it makes a difference in the lives of the child, because that is where justice truly is measured, whether or not they get to grow up at home. Thank you very much, Tribunal members.
This is the sound of one voice, one spirit, one voice. Sound of one makes a choice. This is the sound of one voice. This is the sound of one voice.
This is the sound of all of us. Sing with love and the will to trust. Leave the rest behind and we'll turn to dust. This is the sound of all of us. This is the sound of all of us.
Six years earlier, in February 2007, the First Nations Child and Family Caring Society and the Assembly of First Nations filed a discrimination complaint against the Department of Indian and Northern Affairs at the Canadian Human Rights Commission. 2 years went by. In September 2009, the Canadian Human Rights Tribunal began its hearings. But once again, there was a delay of 2 years following the appointment of a new tribunal chair. March 2011, the government succeeded in having the complaint dismissed on a comparator issue. The Caring Society and the AFN applied for a judicial review of the tribunal's decision, and in February 2012, 5 years after the filing of the original complaint, the appeal was heard in federal court.
Smudge is used for healing so that we are reminded to stand sacred with the Creator when we make decisions, when we serve the people.
I have a lot of hope as I listen to the opening exchanges here at the Supreme Court that the children in our communities will be seen, their vulnerabilities will be exposed, and we will respond with great urgency to make sure that every single one of them knows that Canada and First Nations leaders and parents, we care about them and we want to support them in every way possible. In this case, we're reaching out and they are standing with us to stand up for First Nations children.
It feels good because I know there's something wrong in the world and I want to fix it.
Well, absolutely. You're standing up to support the First Nations kids, and the kids are going to win because you're here supporting them. So thank you to all of you for what you're doing. Very excited to meet all of you.
We had so many people wanting to come here and participate and learn from this that we had to put them in shifts. We've had children here as young as 6 who have sat attentively, respectfully, who have listened, who have learned, and who have formed their own opinions. And what gives me such great hope is when they grow up and they have families of their own, they will have a different place of information to make decisions about what they're going to tell their children about First Nations peoples and the country of Canada and our responsibility to care for one another.
So if we turn to the Act, starting with the purpose at Section 2. Purpose is to allow individuals to make for themselves lives they are able and wish to have without being hindered in or prevented from doing so by discriminatory practice. Anything bad that happens to you because of a discrimination, anything bad that someone does to you because of a prohibited ground is suspect under this Act. That's the purpose. Those prohibited grounds should not hinder anyone from having the lives they wish to have.
But it still suggests it's relative to something.
It's relative to something, and the case law has said, including Vilven, that it is an inherently comparative concept, discrimination.
And Whittler says that. I read it last night.
Whittler says that as well.
That, yeah.
But the comparison is you suffer because of your ground. Therefore, if you didn't have the ground, you wouldn't suffer as much. That's the comparison. Because they are First Nations children on reserve, they suffer from inadequate funding, inadequate child welfare services. But for that, if they did not have this prohibited ground, they would not suffer. And that's the comparative aspect. We don't take issue with the fact that you have to compare what would be your situation if you didn't have this ground. But it doesn't incorporate this notion of who's the comparator and do you have one or two service providers in issue. You have to look at what is the service and are you suffering a disadvantage as a result of the prohibited ground. First Nations children are the only ones where it falls under federal jurisdiction. So it is understandable that this case challenges us.
On our side, on the side of children, there are 5 different legal parties with 12 different lawyers, as well as legal advisors in the background and law students. And I think this is a nice thing for First Nations peoples, because on Canada's side, there are 2 lawyers sitting at their bench. Now, of course, they have the whole Department of Justice behind them, but they are outnumbered in the parties, and I don't know how many people are here supporting Canada, but I don't think the crowd is quite as large as who are here to support First Nations children.
So to answer your question, who is the federal government treating differently? The answer is the First Nation child on reserve. And how are they treating them differently? Differently to what? And the answer to that is differently than they would be if they were not First Nations.
Not First Nations on reserve.
On reserve. The discrimination is you treated me differently than you would have treated me if I was not this color, or this sex, or this sexual orientation. That is the comparison. Yes, there's a comparison inherent in the assessment of discrimination, but that's the comparison. And when we look at a comparator group, the purpose of that is to show evidence that this is how you would have treated me if I was not. The Act does not say you discriminate against me if you treat me differently from a comparator group. It says you discriminate against me if you differentiate adversely in relation to this individual on a prohibited ground of discrimination. You treat me worse than you would have. And that is the merits of the complaint. Is the First Nations Child and Family Caring Society and the AFN going to be able to establish that on the merits? Is the evidence going to be able to demonstrate that? We will find out when the tribunal has a hearing on it. Which leads me to the question of what can this court decide as opposed to what it can't decide and what the tribunal ought not to have decided. That narrow question, does Section 5B always need a comparator group? In my submission, you can decide that issue.
I can.
You can decide that issue. You ought to decide that issue. You ought to decide it differently than the Canadian Human Rights Tribunal did. That's the bigger picture. In my respectful submission, you ought to also keep in mind the smaller picture. Individual families and members of First Nations across the country who are affected by the discrimination that's the source of this complaint. Whether that's the small child on reserve in BC who's taken out of her home because there's funding for foster care, but insufficient funding for in-home care. Whether that's the young boy on reserve in Northern Ontario whose life is at risk or is making bad choices because the social services needed to make the environment to make better choices are not provided. That's the smaller picture for this complaint. And that's equally important, if not more so, than the bigger picture.
So Amnesty International is here today in support of the applicants. And we're seeking to assist the court, as we did as interested parties before the tribunal below, on some of the principles of international law that we say are raised in this particular application. And the principle here is that legislation, domestic statutes, have to be interpreted in such a way that they're consistent with Canada's binding obligations under international law, human rights law or otherwise, unless there's a clear legislative intent to the contrary. In the case of the Canadian Human Rights Act, this is not a piece of legislation that in some tangential way engages a set of international obligations. It is a piece of legislation that was enacted and relied upon by Canada to meet those international obligations. But the tribunal's approach, by its own language, says that it's something, international obligations are something that may be considered as part of context. This, in my submission, impermissibly dilutes the required analysis in HAPE and amounts to an error in law. It's difficult to reconcile the government's position in this case, its interpretation of the Act, its conduct in respect of funding First Nations children on reserve with the obligations that Canada has committed to internationally, its human rights obligations. So Amnesty's focus has really been on that, and frankly, we've yet to hear from the other side a convincing answer to how you can reconcile the program and the interpretation of the Act with the content of those obligations. And that, for us, really remains a serious problem.
What this motion was about was to dismiss the complaint on the basis it didn't meet the statutory requirement of Section 5 of the Canadian Human Rights Act. As you stated yourself, Justice McTavish, on Monday, I believe it was, it's a threshold issue. And I prefer threshold to kind of preliminary because I think that really does describe it really well. It's kind of the first hurdle that this complaint has to meet. If it can't get past that hurdle, it's not a complaint that's acceptable under the Canadian Human Rights Act. How was the motion heard? This was heard on the basis of evidence being provided by all parties, the complainants and the respondent, by that evidence being tested through cross-examination, and then all of that evidence being placed in front of the tribunal and having 2 days of oral submissions. And what was the result of the motion? The result was that it dismissed it on the basis that Section 5 of the Act did not contemplate 2 service providers. So on the basis that it didn't meet that requirement of Section 5. In terms of whether or not it applied to this particular case, what she did is she accepted facts that weren't in controversy. She accepted facts that had been put forward by all parties. And again, I'm not speaking about the facts about the merits of the complaint, and we're not even speaking about the facts that go towards how the respondent was characterizing the funding provided to First Nations. The only factual issues that underline whether or not that particular legal finding applied to this particular case, the first is that the federal government funds First Nations children on reserve, and the second is that the province funds children living off reserve. Because those are the only 2 factual issues that you need to know that once you've made this determination, well, a complaint can't go forward under Section 5B if there's 2 service providers. All you need to look at, were there 2 service providers here? Federal government funds this, provincial government funds that. Then it was easy for her to look at it and say, okay, well, here we definitely have 2 service providers. It's agreed on by everybody. In some ways, she didn't even really particularly need to make a factual finding because those just were the facts advanced that underlined this particular complaint.
I think it stands as self-obvious that this tribunal is in the business of dealing with complaints of discrimination. This very issue that the tribunal was called upon to determine goes to the heart of that very business that it is in, so to speak, and there is no reason or principle by which to depart from that in this instance.
Your friends argued that another consideration that should be looked at in evaluating the standard of review is the considerable importance of the issue to First Nations people. Is it the nature of the issue, the nature of the question that I have to look at, or can the importance of the issue be one to take it outside of reasonableness review?
We would respectfully submit not. The Canadian Human Rights Act is an act that applies to all Canadians. And certainly this case is important to Aboriginal Canadians. We don't take issue with that argument, but it applies to all Canadians. And it would be problematic if one individual or class of individuals argued that a different standard should apply to them. No, it's really about the question of whether you can compare 2 different service providers providing a presumed service to recipients. And in our respectful submission, the 2 are different.
Using this case as an example, and this is a hypothetical, okay, and I'm not attributing this to anybody, but if the federal government set out and said, you know what, we don't think First Nations children are worth it. Therefore, we're going to grossly underfund this program because these are First Nations children and we don't care about them. And again, this is a hypothetical. That would not be discriminatory? I'm not suggesting that this is the case here at all, but I just want to understand where your argument takes us.
Well, the argument, there may very well be, and if there is a basis to assert and establish that that there are inadequacies in funding, there may very well be a basis to pursue a remedy. But this particular piece of legislation and this process is not the only way to pursue it, and it's not the one, based on parliamentary intention, it's not the one that should be followed here. Not every claim gets to trial. Sometimes, despite the subjective belief in the veracity and the importance of the claim, claims are struck for disclosing no cause of action. There are preliminary determinations of questions of law. There are motions for summary judgment. It's not always, or even if it does get to a full trial, the judgment doesn't go your way. It strikes us that what they are really asking for is something more approaching what the Supreme Court of Canada has characterized as a commission of inquiry, or at least some review and address the concerns that the applicants and others have brought forward. For those reasons, at least on these 2 points, we say that the tribunal's decision should be affirmed.
I'd like to thank all of the council. I'd like to thank the audience for the interest you've shown in the case. It's obviously a difficult issue. I understand there are major concerns about delay. I'm aware of that. I will do everything in my power to get a decision out as quickly as I can. But it is a tough case, and I want to do the best job I can. So it's not going to be tomorrow, and it's not going to be next week. I will get it out as quick as I can, but you're going to have to wait a little bit longer. All right? Thank you very much.
I've always believed that your work chooses you. I worked in a group home when I was paying my way through university, and I became really bonded with the kids there. I saw the injustice of so many Aboriginal children. And then because I didn't have any money to continue on in graduate school, I had to stop and work, and I became a child protection worker. And again, saw so many Aboriginal families in these desperate situations. And too often they weren't of their own creation, and yet those families were being held accountable for things they couldn't change. And I thought someone has to do something about this. I want this generation of kids to know one thing. I don't know if we're going to be successful at the tribunal, but I do want them to know that we love them enough to fight for them. And if that means sacrificing this organization or my job to do it, then let it come. Because each one of those kids is far more valuable than a caring society. And each one of those kids is far more important than any job.
2 months later, Justice McTavish grants their application and sets aside the tribunal's decision to dismiss the complaint. The case is set to go back to the tribunal. In the meantime, Cindy Blackstock learns that the government is spying on her in retaliation.
Can you tell me exactly when did you know that you were being spied upon?
Well, what I knew is when I actually got the documents, which was in the summer of 2011. And one doesn't like to think that this happens in Canada. You really do need to see evidence of it. And I saw very clearly there that the government, both Aboriginal Affairs and Justice, were on my Facebook page. I then did a subsequent request, and I found out from the government's own documents that the reason that they were on my Facebook page was because they were trying to prove other motives for this child welfare case. And they were collecting not only information that one might associate with your public life, but very clearly very private and personal information about me and other people that posted on my page.
Why were they looking for it? Was it because of your work?
Because we filed this complaint in 2007, and I really believe the evidence is so overwhelming that the government is discriminating. They've spent over $3 million trying to derail this case. I think this spying on my personal Facebook page was just another effort to thwart the case.
During the preliminary hearings, the complaint was amended to include allegations of retaliation.
Do you guys want to go and see the lawyers? Hello. I heard we met you last time at the Supreme Court.
Oh, yeah. That was, you brought us good luck that time.
Oh, I hope we do again.
I'm a lawyer with the Human Rights Commission. We try to represent those who cannot represent themselves. And we represent as well the system. And we try to give assistance to all the parties, everybody. You know, the respondent, those who answer, those who have to answer, and those who are asking on the other side. And that, in a way, that's why we're seated in the middle. because our job is to, listen to them and to give our opinion to those who make the decision in the front.
These motions today are preliminary motions on evidence. We're not going to be getting into the real nuts and bolts of the issues until the date is set for the hearing. I was called to the bar at the same time as Section 35 was introduced. Even since that time, I've noticed some major changes. A lot more respect, more openness for our culture, traditions in the court. We certainly aren't where we'd like to be or where we ought to be, but we're getting there.
We should have been here 3 years ago had this case not been dismissed by the tribunal chair, but we're back again. And I think that speaks to the fact that our community members and the children from all over this country and around the world are not going to give up until justice is done. And that's why I believed so strongly in involving children even in these hearings. And I am so honored when children come into the hearings and learn about it and speak to it about it with their families and with their friends. I think people, and no matter where they are and no matter what age, they understand that it's not okay for some children to get less because of who they are. It really is as easy as understanding that the government of Canada really isn't doing the right thing for kids. And in fact, they're fighting to continue to do the wrong thing. You know, there's two tests that the legal people will look at. One is what you're saying actually about the matter that's being heard? So do these experts have something important to say about what's happening to kids? And then the second one is, does it make one group look really bad? So you're going to hear the words prejudicial. Who knows what that means?
Prejudice.
No? That's a tough one, isn't it? So what that means in this legal context is it makes one group of people or one group, in this case Canada, saying, it doesn't make us look very good if you talk about residential schools. And even though it might have some links today, we're thinking that if you focus or if you hear from someone talking about residential schools, it makes us look so bad that it's not a fair hearing anymore. So that's what they're talking about. You hear the word prejudice, that's what they're worried about.
I think this is one of the first legal cases in Canada where the history of residential schools and its impact on First Nations children has really been put at issue, broadly, that it really was systemic discrimination. And that's a point that we want to make in this case. And, we find it very disappointing that the government of Canada, who funded, again, the historical study about residential schools and the Royal Commission on Aboriginal Peoples, is here trying to keep that evidence out of the hearing room.
February 25th, 2013. The proceedings finally begin.
Order, please, all rise.
Good morning. Quinganal Aloamwa, Anishik to the Algonquin Nation for allowing us in their territory. Well, this discrimination complaint was established or initiated in 2007. It's been almost 6 years, and it's regrettable that it has taken so long for this day to come. But while this timeline may not seem to be very long in terms of legal processes, and it certainly is a long time for the children and the families and their communities. I have a nephew whose firstborn child was going to be taken from him immediately, as soon as the baby was born, as a result of his partner having previous Children's Aid Society situations. And because of the family and the resources that we were able to pool to provide legal representation in the courts, we were able to prove to the point that it was unfair that he as a father was going to be denied the rights to care for his child. But fortunately, the courts had ruled in our favor, and that my grandniece is 13 today, but you sit back and you look and you question as to where would she be today if other family members didn't come to the rescue of their nephew. The other question is what about the families who cannot afford legal representation? Excuse me. I didn't expect it. So you can understand as to why this is important to us. No family member should lose their child. To be taken out of their community, to never know who they are, to never know where they came from. They will always go through life wondering what's wrong with them because they don't have that background. And that's what's so important to us, is our communities, our families, the attachment to the land. And I know we try and tell you this, and sometimes it's hard to explain how we feel. But I always look at my niece every day and give thanks that she's still with us. And we don't have to search and look for her to find out where she's at. Anishik, thank you.
Thank you, Deputy Grand Chief Denise Stonefish. We will now adjourn for 20 minutes.
Canada should be seeking to be a leader in addressing the human rights issues for First Nations. It's held, at least to a certain extent, an international reputation of protecting and advancing human rights. And yet here we find an instance where children within the boundaries of a first world developed country like Canada receive 22% less funding for child welfare services. So I want to make very clear, the patterns that we've seen in the residential school are being perpetuated again in child welfare. And the relationship requires fundamental transformation. Okay, thank you.
Do you solemnly affirm that the evidence you are about to give to this tribunal is the truth, the whole truth, and nothing but the truth?
I do.
Please state your full name for the record.
Cindy Blackstock.
Thank you.
Thank you.
I want to discuss, for the tribunal's benefit, we're going to be hearing a lot about child welfare services in this case, and perhaps ask you to tell us what is child welfare.
Well, beginning in about the 1980s, First Nations were very concerned about the way the provinces were delivering child welfare to First Nations children. There was something called the 60s Scoop. And what that was is provincial child welfare workers were conducting mass removals of children. And in fact, there's stories of child welfare workers taking buses onto the reserves and removing that number of children. And many of them were placed for adoption in Canada and outside of Canada, but never returned to their family homes. So First Nations were very concerned about this, and they called on the provincial and federal and territorial governments to ask for a resumption of a responsibility to care for their own children. The federal government did not want to fund self-governing First Nations laws, the laws that had cared for our First Nations children for thousands of years. Instead, what they said is, fine, we will do this, but we're going to require First Nations to follow provincial and territorial legislation and standards as a result. What emerged from that were First Nations child welfare agencies. A dear friend and mentor of mine from the Niska Nation said to somebody who was asking him a question, he said, well, why do you need your own child welfare agency? And he said, you know, there's only a few hundred Niska children left in the world today. We can't afford to leave even one. Our languages aren't spoken in other parts of the world. We can't go visit other peoples to regain what is lost for us. We need these kids to be raised at home in their languages, because fundamentally what's at stake is the survival of our peoples. We know in general, although there are some experiences, and it needs to be said, and I am not an idyllic believer. I think some First Nations children need to be in child welfare care. But the vast majority of them, I think with proper interventions, could stay in their family homes. There's no reason for First Nations children to be overrepresented. And we have emerging research from all over the world suggesting that when children are in care, their educational outcomes are not as good. They're more likely to have mental and physical health issues. They're less likely to achieve the job of their dreams. They're more likely to have substance misuse issues, more likely to have engagement with the Young Offenders Act. And I have sat around the table with a lot of kids who have turned 18. You know, the state makes a lousy parent. It really does. Even as good a job as you try to do as a social worker, the state isn't there when that child is 18 years old and has nowhere to go when they're discharged from the child welfare system. Thankfully, in the provinces, there's things called post-majority services, but the federal government's funding cuts off at 18. So these kids are left often without their family connections. They are being, they don't know who to call when they have their baby's first birthday, and all those things that come with having grown up with a family are very difficult for youth who are in care or those youth who become young adults out of care.
I'm a Mi'kmaq from this community. I live just up the road here. I was taken away at a young age from the community, about 6, 7 years old, and I was put in foster homes. I've been through quite a few different foster homes, and when I think I was about 7, 8 years old, I got put into one foster home in Thorburn, and there was a good foster home, and I lived there pretty much most of my life. And I came back into this community about 2001. I am happy to be living back here. I enjoy it. It's a beautiful spot, and concerning the environment, that's where my studies are. I would like to see this community cleaned up and be more healthy. My foster parents never took me down around here because I do recall running away from a foster home and trying to come back to the community, but so they put me out further away, so I just stopped running away from the foster homes. Yeah.
Did you remember that you had sisters and brothers?
Yes, they kept us in contact. The Mi'kmaq Family Children Services kept us in contact for my brother and I together in the same foster home for a few years, and then I think I was in my teens when I ended up meeting my other brothers and sisters.
What was that like?
I was glad to meet them, and I wish they would have kept us in more contact throughout our lives, because today we don't keep in touch with each other today, which is sad.
I remember working with the Squamish Nation workers when I was a social worker with the province, and I heard them talking about the deficits in services. And to be honest, I thought they were over-exaggerating until I actually worked in that office. And I felt like every time I would try to access a service to a family, there was often a barrier to that access. I was I devoted so much more of my work to trying to simply get access to services. And that's something that was very unfamiliar to me, because we had this whole division that would be looking after that in the province. So some of the deficits were I came to know a formula called the directive, simply because I would question, well, why isn't this service available? Why aren't we providing this service? Well, there's only X amount in this directive. And I'd say, well, what is this directive? Like, I'd never really heard about this directive before. And I came to understand that the whole funding for prevention services under the directive is based on population thresholds set by the Department of Indian Affairs.
Directive 20-1 funds the program based on formulas for operations and reimburses eligible maintenance expenditures according to actual cost. Operations funding, which includes salaries, travel, insurance, etc., starts with a base amount of $143,159 for an agency that serves a child population of 1,000 or more. Communities that have a child population of 250 or less do not qualify for their own First Nation agency.
Which I personally think is wrong, because I think all children deserve access to culturally based services. But nonetheless, that's the way the formula works. If you're between 251 and 501, you get 25% of what the operations funding of which the prevention services are a part. And then 501 to 801 is 50%. 801 to 1,000 is 75%. And then if you have 1,000, you get over that threshold. But there's no margin of increase between these thresholds. So even though we were serving 790 some odd kids, we were funded as if we were at 500. There wasn't enough money in there to do any kind of what I would say is evidence-based and needs-based prevention services where we could go out and identify the needs of families in our area, design with the best evidence prevention programs that would tailor to those needs and be able to run them in a sustainable way. That was not available there. So we would end up either doing without or scrambling around and trying to fill in the gaps in other ways.
In 1983, when the four chiefs negotiated for their agencies, they did what they call a line-by-line budget. And as we all know, line by line, how many social workers will you need? How many services are you providing? What programs do you want to provide? So every line, every detailed line had a dollars attached to it. And it was an accurate budget based on the needs of the community at that time. And then Program Directive 20-1 was announced. In New Brunswick, the chiefs of New Brunswick rejected that adamantly. They knew that it would have a negative impact. And as in most things, it had most of a negative impact in the smaller communities, because it was going to generate your amount of funding based on the population, not based on the services you required or wanted to provide. It was based on population. And when they introduced that, there was a cut to 5 of, at that time, there would only have been 10 agencies, in the tune of $218,000. Well, that's not a lot of money to some people, but when you're a small agency providing services to children, it's a lot of money. Even if it's $20,000, $30,000, $50,000 or $60,000, it's a lot of money to a small community.
Is this the hand-in-hand report?
Yes.
When you look at the report, and I'll draw your attention to page 18, the perverse effect of Directive 20-1 is that it actually forces more children into care by increasing funding depending on the number of children in care.
There's a budget in Program Directive for operations, and there's a budget in Program Directive 20-1 for maintenance. The maintenance money is for children that you apprehend out of the family and place into a family, either relatives outside the community, another neighboring community, but the child is no longer in home. So you want to provide services to the child, you're forced to apprehend the child and take the child into care in order to provide that service. And in the province of New Brunswick, they're not big on apprehending children in First Nation communities. They are very big on the fact they want to provide services in the home. Why would we fix the child without fixing the family?
Were you able to have access to partners like the voluntary sector to assist you to the same extent as you did in the province?
No, I mean, that was one of the biggest differences. So the province, of course, when I was working in the province, the ministry itself would contract out to these other specialized service providers. We had access to child counseling, parental counseling, youth programs, a whole host of these services that were available right there. And on reserve, there was no other money other than that small portion that was provided under the operations formula at the 50% level. So I would call up my colleagues who I'd work with off reserve And I would say, we have a family in need, and could you please provide the service? And they would say they were not funded to provide services to First Nations people on reserve. And I would say, well, who funds that then? I mean, these are children in need. Well, we got the contract with the province to provide it off reserve, but we don't have a contract to provide it on reserve.
What did it mean for your agency to be under 20-1? What impact did it have?
It was very adversarial between ourselves and community members and leadership, because we were forced to basically just do apprehensions and place children in care. And I wasn't happy with that. I wanted to be proactive. And this goes back to our history as a First Nations people, including my history, where, you know, having to endure boarding school, like my dad, my late father was in boarding school, and the damage it did to us, or the interference that back then that the church had on our family systems. So I wanted to get away from that. Like, having lived that experience, we don't need more interference. We don't need more, for lack of a better word, wreaking havoc on our families. I come with the frame of mind that our families need healing. And I, as a trained professional, and others out there in Saskatchewan and the other agencies, you know, like, there's got to be a different way to do child welfare other than breaking families up. We want to heal. We need to heal. We have to do things differently. Like, on a personal note, I went to law school. I finished my first year in 1986. At that time, I came across a young fellow that, I guess, at that point, had nobody to care for him. Meeting Frankie for the first time, I guess you could say I fell in love. Anyway, we opted to care for him. And because of his needs, we had to get training. Frankie came with a lot of medical equipment, a lot of medications, a lot of therapies. So I took time off to, as I like to look at it, to become a dad. You know, all through his life, I never heard him complain. Just carried on, and as he grew older, he eventually, you know, got better, so to speak. Like they told us, don't expect him to walk or talk. It took a while for him to walk, but he eventually walked, and then he talked. And his gift was music. You know, like, he had such a beautiful voice.
All we need is friends like you and me. We need some friends. Brenda will get friends for us. We need some friends like you and me and you. We need some friends like you and the classroom, yeah.
I know when he got older, I would sing along, and he'd always tap me and say, "Dad, don't sing." Yeah, he was a blessing. You know, like, it just changed my life, and like I said, that's how I got into child welfare. Because he was hydrocephalic, he had a shunt, and in his last year, like, it kept plugging and plugging, and the last time it plugged, we couldn't get to the hospital soon enough. Brainstem hemorrhaged, and we lost him. That's what I learned in taking in Frankie, the gift that you get when you do that. Because not only did we take in Frankie, but his family took in us. You know, it was kind of like an exchange. Yeah, he's taught me a lot.
What about the salaries of social workers?
Provincial social workers, as we all know, they would go on just like anybody in any other profession, they would go on a salary scale based on their qualification, years of experience, training, whatever. In First Nation, that doesn't exist. In the operations formula, it is a formula that's based on numbers, and it's based on the number of children you have in the community, not based on the number of staff you require, the qualifications of your staff, the training requirements of your staff. So the director, with their band council in many cases, they sit and decide how much they can afford to pay staff. 90% of them are underpaid based on their provincial, in line with their provincial counterparts.
So they're not making the same money as the provincial
They are
counterparts?
not.
What about other types of support, janitorial staff or
No.
other types of staff?
In the operations budget itself, it basically is for social work staff. Now, depending, once again, understanding the Program Directive 20-1, if you've got a high population, your money is going to be higher that you receive in operations. And that's where the majority of your budget is spent out of for staffing, for training, for travel, for admin support, for janitorial service, for snow removal, for lawn care, for lights, phone, fax, anything that you need, that's where it comes from. It could be parenting programs. It could be anger management programs. Anything that the director feels is appropriate to the needs of his or her clients that they work with must come out of the operations budget. And as a result, it leaves the budget very, very depleted when it comes time for, I need a raise, I need more staff, I need a case management system. I need a new computer because mine is 8 years old. I need a security system here. I need a filing cabinet that is a fireproof filing cabinet. There's a significant number of needs that are not necessarily luxury items. They are what any social worker working in a provincial system would expect.
Infrastructure under 20-1. So let's speak about buildings and computers. Were they covered?
No.
Your agency serves, what, 5 bands?
6.
6 bands? Do you have an office in each of those?
Yes, we do.
How did you pay for these offices?
Well, in most cases, the band or each individual nation has given us a house. Most of them are houses. We do have an old daycare on one that we've refurbished.
I assume you need to travel.
Yes, we do.
So were vehicles covered?
No.
How does 20-1 handle capital investments?
There's none.
None?
None.
So none for buildings?
Nope.
What about computers?
Nope.
Vehicles?
Nope.
So where do you put your files?
The files in New Brunswick, and it's been an issue for a long time, they're housed in ordinary filing cabinets that you or I might have. However, under social development, the requirement for all files is to be housed in a fireproof locked filing cabinet. And in one of the compliance reviews that took place in Tobique First Nation, where I was present, the federal government employee at the time said that funding would be made available. And I do believe those filing cabinets cost, and I could be wrong, around $2,000 each. Funding would be made available to all agencies to purchase such cabinets. Has it ever been done? No.
In Eskazoni, the building is severely overcrowded. We've just recently, the Eskazoni band has leased a portable trailer and set it up for us, and we're renting it from them, adjacent to our office building. Even with that building, we have crowding issues. I mean, you'll have 3 social workers sitting in, say, a 5x10 room with 3 desks, and it makes it difficult. I think the next step is to put a desk in the bathroom, but somehow the staff didn't want me to do that. It's very overcrowded.
In 2008, the Auditor General undertook a review of how child and family services were delivered. She found many problems. Program funding was unjust, based on outdated formulas, and she made a number of recommendations to improve the program. Recognizing that the 20-1 funding formula was not effective, the department introduced a new funding formula called the Enhanced Prevention Focused Approach, EPFA. They began applying it in 2007, starting with Alberta.
Well, this new formula did one positive thing, and that was it was attempting to create a new stream of funding, a separate stream of funding for prevention services. So now we have this new prevention stream, the maintenance stream, and then we have the operations stream. So we're now looking at 3 different streams. And the Auditor General is saying that this increase should lead to better services for First Nations children. The Auditor General goes on, however, in 4.64, and saying that the new formula does not address the inequities we noted under the current formula. The formula assumes that 6% of children in any given First Nation will be in care. And while that might be true for communities that do have 6% of children in care, the Auditor General was pointing that there's wide variation for that, and there's no accounting for those differences in the formula. And consequently, in our view, she says, the formula will not address differing needs amongst First Nations. Pressures on INAC to fund exceptions will likely continue to exist under the new formula. The department talks about the plan is to complete the work by 2012. And as tribunal members might remember, we still have the First Nations in British Columbia, the First Nations in New Brunswick, the First Nations in Newfoundland, still operating under the directive, and it is, of course, 2013.
When you went to enhance, there was a net benefit for your agency, though.
Yes.
Okay. Financial benefit, I mean.
Yeah, there was. Yes, there was. I mean, we did receive more money. It was a good thing we did too, because at that point in time, we didn't have enough money to keep on operating under the existing formula. The benefit of that additional funding was soon eroded because there was no real provision for what we actually need. Normally, when you're budgeting, you would say, okay, I need this many bodies to achieve that much. And here is what I need in order to operate efficiently. Well, that's not what happens when we had the enhanced funding. It was, here is the money that you are getting. And at the time, I did say that, it would not be sufficient. My 5-year forecast showed us in a deficit position by year 4, which happened, and it's worse than I even predicted.
Okay.
When I worked at Casoquel, we had 18% of our First Nations children were in care.
And the assumption under enhance is 6%. What does that difference of 12% mean for your services?
We have a high maintenance budget and low money in operations. The caseload is not 20 to 25 as per provincial standard. It's more like 35. We wanted the 6% changed. The federal government would not budge on the 6% figure. And as a comparison, we had the services that are provided to First Nations children who are in care with the province. They get a better service, and they get more supports, and they have access to more resources off reserve. So in essence, if you were to ask me, if my children were ever to come into care, I would want them to be apprehended off the reserve and not on the reserve.
We have in the South, I believe right now, 4 agencies that exceed those assumptions. And one of them in particular, they have 14% of their child population is in care. So anything they might have for prevention, they can't do because all their money has to go. They have these kids, they need workers, they have to service that workload. And there's no way, under the funding model itself, there's no way to adjust for that.
Are you in any way limited to what services you can provide on reserve?
Yes, I'll say we're limited. We try and focus as best as we can on prevention programs. I'll give you an example. Big or small, we have 16 First Nations. We provide $30,000 per community for projects, whether it be addiction-related, professional services, parenting, anger management, counseling, whatever $30,000 can buy in 1 year. But like I said, $30,000 for the whole year. We tried to do an intervention with one family where there was it's a family of 7. 4 committed suicide in a matter of 1 year, and we had to get these specialists to come in at a cost of about $175 to $300 per hour for these therapists to come in. For that one case alone, I believe it cost us about $70,000. If we did that for every family that are of high risk in our agency, I don't think we would be in existence. I think we would be in a danger zone. We had to fundraise for a wheelchair. We had a child with cerebral palsy, but she wasn't eligible for a wheelchair under the INAC or the health. So we had to do some fundraising, and they're very costly. So, but the staff went out in the community and we raised the money.
And that child, was it a child in care?
Child in care.
And how does the province treat those expenses? Are they eligible or are they ineligible?
They would be eligible.
Eligible expenses? And where would they get that funding?
Under their maintenance.
Under maintenance.
The solutions are always there. If you look at this human rights complaint, the answer to the remedy to this problem is the one-day report. It was a joint project by the Assembly of First Nations agencies in Canada, and Department of Indian Affairs. It's sitting on a shelf somewhere. They come and tell us, this is what you're going to use. These are the tools that you're going to use. These are the assessment tools that you're going to use. And this is how we're going to fund you. And this is your information technology that you're going to use. And we're saying, wow, can we have a say in that? So we declined to accept those. So we developed our own information systems, case management information systems. We've developed our own programming on reserve. And even though it's with little or nothing, we created success for families, leadership, our boards, staff, and more important, our children.
One of the things that I recall from your evidence was that, or at least something that you feel is important, is to have First Nations themselves having a role to play in the development of the delivery of child welfare services on their reserves and having some control or say over how programs are developed. Is that fair to say?
I would agree with that, yeah.
Okay. The EPFA is relatively new, given that the first one in the first province was only implemented in 2007, and we're now in 2013.
Well, that was 6 years ago. I would use a different adjective to describe the time period than relatively new.
Well, you've been working on this issue with the federal government and others in collaboration and other things for a much longer time than 6 years.
I know, and that's the tragedy that we find ourselves here, despite all of that collaboration and all the equitable work. And
yes.
I certainly hope that at any time we would see a movement by the federal government to ensure full equity for First Nations kids, because their childhoods are precious.
Would you agree with me that since 2007, there has been progress in, or at least changes in 6 of the 10, or at least in several provinces, representing a majority of the population of First Nations children on reserve?
I was reading a report recently, and it has a phrase that says, can anyone hazard a guess as to what year or what century real progress will be made towards the equality of First Nations, or it says Indian children? That was written in 1967, and I was 3 years old. The problem with incremental equality is that it hasn't come for First Nations children yet. And so, although those are important steps, I see equality, equity, and comparability and culturally available services as the floor and not the aspiration for First Nations children.
Was Was that in response to my earlier question?
Yes, it was.
All right. Is it your view that the EPFA does not represent at least an attempt, a new approach?
It is an
try-
attempt on a new approach, but I think kids deserve success, not just an attempt.
But I believe when you were discussing other possible approaches, you indicated that there needs to be some flexibility or consideration with respect to time, saying that roughly 5 to 6 years is long enough.
This formula was, as you mentioned in your comments, Mr. Tarleton, was implemented in Alberta in 2007. The Auditor General reviews it in 2008 and finds it to be, in paragraph 4.64, to be an improvement on the directive, but to incorporate some of the fundamental flaws of the directive. It finds it to be flawed and inequitable. The Auditor General, then the Standing Committee on Public Accounts takes a further look and finds that those problems still remain. The Auditor General takes a look in 2011 and says that there is unsatisfactory progress on the issue of comparability in cultural programs. The Standing Committee on Public Accounts takes another look at that and agrees with those findings. And then the United Nations Committee on the Rights of the Child finds that there has been unsatisfactory progress towards the implementation of an Auditor General's report. If we were looking at something like that's static, that's not as critical as child development, we've been at this, as you quite rightly said, just my own personal involvement. We've been trying to get the children to a place of culturally based equity, at least on the directive, since my early involvement in 1997. Those children are now 16 years old. I think that we can do much better for children. I think the Government of Canada can do much better and avail itself of the many solutions that are out there. I think 16 years is way too long to wait.
Thank you very much, Dr. Blackstock.
Thank you very much, Mr. Tarleton.
Order, please.
So can I talk?
Though the case was already underway at the Human Rights Tribunal, today at federal court, the government appeals the earlier judgment of Honorable Madam Justice McTavish, hoping to once again stop the tribunal hearings.
At the outset of our argument, we would ask the court to keep in mind this overriding concept or theme, 2 versus 1. This case concerns comparisons of 2 different governments as service providers to 2 different recipients or publics. The case law that has been relied upon by all of our friends concerns 1 service provider as opposed to 2. Similarly, the examples that have been provided by the applications judge in her judgment and determination that the tribunal's decision was unreasonable all speak again to 1 service provider as opposed to 2 service providers. It's our submission that this apparent confusion may have contributed to her analysis and what we say is a reviewable error in determining that the tribunal's decision is unreasonable. The second point that we would like to flag for the court, for the panel, is to keep in mind the concepts of difference versus discrimination. Differences do not always constitute discrimination.
But isn't that something that should be sorted out after both of you have had a chance to put your cards on the table on that question? And at the end of the day, you may be right. It may be irrelevant. But it seems to me that it's not unreasonable to say, well, you know what, that's best decided after it's all been heard. That's basically my problem with your position, counsel, is that you're making this a definitional problem, whereas in fact I think it is a problem of proof.
5 days later, Judge Stratus, in agreement with Judges Pelletier and Webb, dismissed the government's appeal, and the tribunal hearings were allowed to continue. Three months into the hearing, Dr. Blackstock received 40,000 documents via an access to information request and discovered that they had not been included in the government's disclosure.
I spent the whole night going through the documents. And then we sent them off to our lawyer. And that's when our counsel writes to the Government of Canada saying we're in possession of this CD that we obtained through access to information. We're surprised that it wasn't disclosed to us. We don't get really a timely response on that. It's not until May 6th that the Government of Canada writes back and says, well, we were just in the process of gathering those information, coincidentally, the ones that you found on this access to information request. And by the way, we have 50,000 other documents that we need to disclose. And we can't get those together until September to December of this upcoming year. And as you know, the hearing was set to conclude in August.
These documents are key and critical documents. They're the centerpiece of the respondent's defense. The report saying, out of Saskatchewan, agencies are reporting that they receive less than 60% of per case funding when compared to what the province spends. Out of Nova Scotia, essentially no prevention services are being delivered. Average caseloads are 20 to 30% higher than the provincial standard. BC, as a result of the manner in which this formula is structured, Directive 20-1 funds primarily the removal of children from the home rather than encouraging the use of least disruptive measures. These are the government's own documents. The enhanced formula is the centerpiece of their defense. I'm a little bit disappointed in the sort of lackadaisical, what I interpret as the respondent sort of downplaying how serious an issue this is when we've got witnesses coming from all over. This is, a really kind of unfortunate time to be learning this.
I, for example, testified for 5 days without the benefit of these documents. The government never once signaled, hey, we have 50,000 documents, and if you take the stand, we may be using some of these documents or relying upon them, or they may have been helpful to you during the testimony. None of that. It was only, that conversation only began from the department after we sent in our letter saying, why were these access to information documents not disclosed to us?
We wish to advise the tribunal that we would like to bring a motion seeking an adjournment of the hearing until outstanding disclosure is complete. Depending on the outcome, that may affect future dates and that have been set for hearing going forward.
It's with deep regret that we find ourselves here at this moment at all. The Government of Canada has known about this case since February 27th, 2007. A child born that day is now 6 years old. If there is any inconvenience because of this particular matter, and the matter in which the disclosure was not made before the hearing is required by the tribunal rules, then that inconvenience and that disadvantage should be absorbed by the Attorney General and not by the 161,000 children who are being affected by this ongoing pattern of delays by the Attorney General of Canada. It hasn't been, I think it's important to look at this as not just one incident, but an ongoing pattern of delays where the government has got in the way of a full evidentiary record being placed before the tribunal for its consideration on the most important issue, which is the well-being of the children. You don't hope for it, but at this point in the case, I've come to expect every tactic possible from the federal government to delay this case on behalf of children. But I'm absolutely determined that that won't change who I am and what I'm doing for kids. And I've made a promise to the children that in this, the fight of all fights for them,
It will always be done, at least to the best of my ability, with the honor and dignity and love that children embody. I will not reduce myself to play on their low ground.
On June 3, 2013, the Tribunal grants a delay of 3 months, ruling that the respondent's disclosure must be completed no later than August 31, 2013. The hearing will continue in September and into the fall until completion.
Let's look at EPFA. How does the formula take into account increases to the cost of purchasing professional services?
It does not. The fifth-year amount continues on.
So in 2012, the agency will receive the same amount it received in 2007.
Yes.
And in
As of
theory,
today, yes.
10 years later, as in theory, if it continues as it is now,
Yes.
after 10 years, they will receive the same amount they received in 2007.
Yes, but there was a reason for that.
Okay?
Because
Now I'm interested.
because the idea of EPFA was that if you placed more money in prevention and did a lot more early intervention work, your maintenance costs would go down. When those maintenance costs go down, that money could be reinvested into operations. So that's why there was no escalator included in here. This is an issue we are now reviewing about what happens after year 5 if the maintenance isn't supplying the operations anymore, or never did. So what if that theory doesn't work? And we're finding that at least, well, in one jurisdiction, it is working. It's working quite well in Saskatchewan, where maintenance dollars are going down. But in other provinces, that's not the case.
And so out of the 6 jurisdictions so far, it's working as intended in only one.
That's right. We're learning now after 7 years of EPFA that regardless of whether the children in care count goes down, the cost of maintenance increases.
With the current EPFA, that amount of money is not subject to the 2% escalator, correct? You're not getting 2% increases.
That's correct.
The costs are increasing, but there's no escalator on the EPFA.
That's right. So we reallocate instead. Especially for the maintenance costs, we reallocate.
The Auditor General says, in a 2006 study, the department acknowledged that over the past decade, budget reallocations from programs such as community infrastructure and housing to other programs such as child welfare have meant that spending on housing has not kept pace with growth in population, and community infrastructure has deteriorated at a faster rate. Do you appreciate how some people might just stand back and look at this and think that maybe it's a bit perverse that you're taking money out of housing, reallocating it to give to child welfare to improve or prop up the child welfare program, but by taking money out of housing, you're creating perverse problems to child welfare by creating those risk factors?
Yeah, I appreciate that, and we said we reallocate resources. We deem child welfare to be a higher priority in terms of risk to children. We have a departmental policy to pay the bills to maintenance, and so in the absence of new funding, we've all determined that we haven't got the funding for BC and other jurisdictions that the department is reallocating.
The next document I'll take you to is tab 412. We'll see that it's an email with an attachment from Deb Foxcraft, the president of the Nuu-chah-nulth Tribal Council.
Correct.
She says, this is a very important and critical issue for the NTC as one of the oldest child and family service programs in BC. In 27 years, we have not received an increase in our operations budget since that time. 27 years of not receiving an increase. Do you believe it's reasonable for an agency to try to carry on these very important and critical services for nearly 30 years without an increase in funding?
And I can't speak to how the BC region has funded that agency and whether they have been getting their maintenance. I'm sure they've been getting their maintenance bills. They got their transition money, but it is true that we have not been able to necessarily increase the operations budgets of agencies. Our focus is really on children in care and maintaining those billings, and operations budgets have not necessarily grown for agencies.
Okay. And then you'll see at the next page, top bullet says, on reserve CFS is not sustainable with 20-1 funding. If the Directive 20-1 formula is not updated, there is a high risk that we and other ANSI-funded agencies in BC will no longer be able to meet standards. That's a risk that your program understands, correct?
Yeah, that's a risk we understand.
So we'll adjourn until 9:30 tomorrow. Thank you.
The complaint also noted the failure on the government's part to implement Jordan's principle, the child-first approach inspired by the life experience of a young First Nations boy.
Jordan River Anderson is a little child from Norway House Cree Nation. Because it was a complex pregnancy, he was born in Winnipeg, in hospital. And he remained there for the first 2 years of his life for medical reasons. It required, as it does for many families who are in difficult circumstances, the separation of the family, because this is a family who had other children. So Dad, for the most part, returns back to Norway House Cree Nation to parent the other kids and to work with the community to make sure all the services are available for Jordan when the day comes that doctors say he can go home. And Mom stays with him in Winnipeg.
Time for the birthday boy.
Is it time to sing happy birthday? Virginia? Yes? Ready to sing happy birthday?
Yeah.
Okay.
Happy birthday to you.
Happy birthday to you. Happy birthday, dear Jordan. Happy birthday to you.
For the next couple of years, things plug along, and there comes a point when the doctor said that he could go home. And the decision is that he would be placed in a family home rather close to the medical facilities in Winnipeg. And so an agreement was signed with the family to bring Jordan into foster care. And if he was a non-Aboriginal child, he would have gone home. The government of Manitoba would have provided the services necessary, and he would have stayed there as long as it was advised by his doctors, as long as his medical condition was stabilized. But because he was a First Nations child, that created confusion amongst the governments about who should pay for his at-home care. So the province of Manitoba took the position that this is a First Nations child from a First Nations community, and thus is a federal responsibility. We then had the Department of Indian Affairs engaged because Jordan was a child in care under this particular program. But there was some confusion about whether they should pay for some of these elements or whether it was their colleagues at First Nations Inuit Health or Health Canada that should pay for it. The end result is that the decision was made that nobody would pay for it until they resolved this dispute about who should pay for what, and the child would remain in a hospital until this dispute was resolved. And sadly, just before Jordan's 5th birthday, he slips into a coma, and he passes away at the age of 5, never having spent a day in a family home. When Jordan passed away, the family and the community wanted to make sure that this never happens again to another child. And so Jordan's principle was created. And Jordan's principle is a child-first principle. And what it says is where a government program is available to all other children, and one of these disputes
arises within or between federal, provincial, or territorial governments, the government of first contact pays for the service first, and then figures out the payment issues with the other respective levels of government as a secondary consideration. But in this way, the child gets the service on the same grounds as other children.
Order. The question is the following one. Ms. Crowder, seconded by Ms. Wazalisi, moved that in the opinion of the House, the government should immediately adopt a child-first principle based on Jordan's principle to resolve jurisdictional disputes involving the care of First Nations children. All those in favor of the motion on my right will please rise.
Ms. Crowder.
Row on my right.
Mr. Blakey. Mr. Scheer. Mr. Albrecht. Mr. Allen. Mr. Brownberry.
There were 262 members of parliament in attendance. They all voted yea. There were no nays. And with a total of 262 votes, a unanimous vote in support of Jordan's principle.
Je déclare la motion adoptée.
The policy response that we were mandated to implement was based on Jordan, and my role is to provide that analysis and advice, and we had to start with Jordan's case and look at those particulars and implement to ensure that if there are other children like Jordan out there, that the federal response as our very first step that we could actually address those cases. So the federal response has sort of key criteria that it's structured on. The first criteria is that a child under Jordan's principle must be a First Nations child who is living on reserve or ordinarily resident on reserve, that there is a federal provincial jurisdictional dispute over the services to be provided to that child, and that there is an impact on the continuity of care, that there is some kind of disruption as a result of that dispute. And then the last part is that the service in question really has to be something that is normally available to children off reserve in the same location. So that's the concept of ensuring that there is a comparable service. So if there is a case that met that criteria, we would immediately begin case conferencing to try and resolve it and to ultimately prevent a jurisdictional dispute. The government of first contact would pay for the disputed service, and then that would continue, and then we would work with the provincial government to ensure who is ultimately responsible to pay for that service would.
And for a case to be deemed a Jordan's principle case, how many criteria have to be satisfied?
Those 4 criteria that I read off earlier, all of those must be satisfied in order for it to be deemed a Jordan's principle case. However, as I mentioned, we look at all cases that come to our attention and we case conference around every case.
Do you know if there are other definitions that exist?
Yes. As we moved out with our engagement of provinces and in some of those sessions, they were tripartite sessions where First Nations were at the table. Some of the provinces had developed their own definition of Jordan's principle, and the First Nations also had their own definition of Jordan's principle.
Jordan's principle applied to government services. Then the federal response limits it to this grouping of multiple disabilities with multiple service providers for reasons that are not clear to me. In my view, the proper interpretation of Jordan's principle is the child gets a service. If necessary, the feds pay for it, and then they can recover the funds from the province if they feel that they should be recovering the funds from the province. But there shouldn't necessarily mean a whole drawn-out bit of negotiations before the child is eligible for any services or Jordan's principle can be implemented.
Could you read the case description for us, please?
Sure. So a 14-year-old residing in a foster home off reserve diagnosed with spina bifida. Dispute ensued between the federal, provincial, and First Nation band regarding funding and payment for personal care services on an ongoing basis.
And the outcome?
Health Canada Regional Office provided one-time exceptional payment costs associated with home care services. BC proposed plan of care to replace expensive nursing care with training and care by paraprofessional.
And would this have met the definition of Jordan's principle?
In this case, no.
And why not?
Jordan's principle really arises when you have a case where we don't have the authority to fund that service and we deem it to be a provincial responsibility. And that's when you get into a case where there's a federal-provincial dispute.
Okay, thank you. And are any of the cases true Jordan's principal cases to your knowledge?
Well, based on what I've seen, sometimes cases come to our attention that have the potential to be a Jordan's principal case. But we haven't had one escalate into a true Jordan's principal case because all of the parties involved are very motivated to, they go into a dispute avoidance pattern to try and make sure that it doesn't turn into a Jordan's principal case.
Great, thank you. Are you familiar with the court case known as Pictou Landing?
Yes, I am.
Could you describe the facts of that case as you know them?
The case in question was a child who was being cared for by his mother. She fell ill and she was no longer able to care for her son. The community was providing an enhanced level of service to the family, pretty close to 24/7 care. And they were asking Aboriginal Affairs and Health Canada to consider this case to be a Jordan's principal case. And they were requesting reimbursement of the enhanced services that they were providing to the child and his mother.
What's going on? I don't know. Yeah, what's going on? Well, we can't get in hold of Donna yet. Maybe later? Maybe later? Can you say later? Or after? After? Your happy sound? Yeah, your happy sound? You're just stuck with Santa, Chris. Yeah, you're just stuck with Santa. He was born with hydrocephalus, and he was later diagnosed with CP. And then later he was also diagnosed with autism. So, you know, he's got 3 disabilities. They told me that he'll never walk, he'll never talk, he'll be just laying there. I said, oh no, he's gonna be walking and he's gonna be talking. And I worked on him. And I did it all on my own. When he was 15, I took a stroke. And I couldn't move, like my arm. I was in the rehab for a month. They wanted to put him into an institution. And I said, over my dead body, they're going to do it. I said, I got to be dead before they take him out of my house.
Says,
There's a lot of workers there. Jeremy has a lot of helpers there that can help him stay home. He doesn't need to be put into an institution where there's no TLC or anything. Just lock him up and throw the key away.
Step on in. Excited, huh?
So I worked harder to get better at what I was trying to do with my body to get myself to walk and stuff like that.
I will follow you. Okay.
Even so, I know that he was already of age to get any help from the Jordan Principal thing. All I really asked for from the start was for the Jordan Principal to be fully implemented to help children across Canada that had special needs like Jeremy. And where, as a parent and as a mother and as a single parent at that, I know the reality of being a special needs parent. Hey? Nobody takes us apart, eh? No, nobody can tear us apart.
And what was the conclusion of the case conferencing? Was it a Jordan's principal case?
So the conclusion was that it was not a Jordan's principal case because based on the criteria, as we saw on the tracking tool, it didn't meet 2 out of the 4 criteria. So in the first instance, the case, there was no federal provincial jurisdictional dispute. As the province had indicated that the level of care that the family was providing is not something that they would support through their respite, their direct support policy for families off reserve. And so that links into the other criteria that was not met, and that the normative standard of care being provided to the family, so it was in excess of the normative standard of care that would be provided to a child living off reserve based on the provincial policy.
And the department actually said, well, if you were to put him in child welfare care, they would cover that cost. But this is a loving family, and in my view as a social worker, I don't think foster care is the right place for these kids, but it's a place where families have to go to get the specialized care that these children need and deserve.
So after the decision was issued, we expressed an interest to continue with case conferencing, but at that time, an application was made to the federal court to have a judicial review of that decision.
Do you know if the judge in this court case found it to be a Jordan's principle?
Yes, the judge disagreed with the federal government and thought it was a Jordan's principle case.
And do you know what is currently happening with this court case?
I understand that the federal government is appealing that decision.
Thank you.
I remember at the ceremony where they won the federal court case. I'll never forget it, Alanis. It was one of those magical moments where there is Marina, and she's and Jeremy's beside her in the wheelchair, and she's kneeled down so she's right at his level. And the powwow drummers are singing in the background, and Marina is playing along. And all of a sudden, Jeremy's hand reaches across, and he starts beating the drum. Get murdered, murdered, down the yellow thick, Nick my should, yes, it's my we done it. Hey, and I think the government of Canada wants to separate those two? Really? Do they really have something better for Jeremy than this?
If there is a Jordan's principle case, so if it's a declared dispute between the federal and provincial governments, and we consider it to be a Jordan's principle case, we can make payment for a service that is not within our authorities, but it would be a temporary payment.
But that would require a declaration of the case being a Jordan principle case.
That's correct.
And that declaration can be made only by whom?
It can be made by the assistant deputy ministers in the federal and provincial governments.
Do they both need to agree that there is a Jordan principle dispute?
Yes, they do.
So some of the provinces do want to use other terms. Their definition is different.
Yes, that statement is correct, yes.
I'm trying to understand how this would work in practice. Because if the province disagreement is based on a difference in definition, how could this ever be a Jordan principle case?
Okay, well, I think maybe the best way I can try and answer that is that in the agreements that we have, we do clearly state that it's only a Jordan's principle case when it meets the federal definition.
Are there any monies set aside for dealing with Jordan's principle cases?
At this time, no. There's no money set aside.
Was there a time when there was money set aside?
Yes. Between 2009 and 2012, Health Canada had established a fund, a Jordan's Principle Fund, that was worth $11 million over that time period, so about $3 million annually. And that was a very specialized fund to pay for disputed services.
Was that fund ever used, do you know?
No, the fund was never accessed.
Do you know why?
Well, part of the issue is that the cases that were coming to our attention either did not meet the criteria to be a Jordan's principal case, or if the cases that came to our attention had the potential to be a Jordan's principal case, the parties were able to find a solution without having to declare a dispute and access the fund.
In 2012, the fund had not been accessed in its 3-year existence, but we applied before the 3 years. The federal government canceled the fund 1 year before the designated sunset time, but we already started asking for it before then.
In effect, since 2007, there has been no cases, which is why the $11 million lapsed.
You're correct. There have been no Jordan's principal cases, but we have had cases that have come to our attention that have the potential to be a Jordan's principal case. But the parties have been able to, through case conferencing, avoid that escalation.
So we have a process for awards at the deputy minister level that's annual. We nominate individuals or teams based on criteria. It was my decision, in consultation with others, to nominate what we called the Jordan's Principal Team. And so it was in recognition of them coming together, working with First Nations and working with the provincial officials on what was a pretty charged, I think, issue. It had drawn a lot of attention. And they, from our perspective, had done good work, collaborative work, to move the process along and to handle cases.
Thank you. And we see at page 5 the list of the people there who got the award.
That's right.
Children have rights. Yeah, children have rights. Like everybody else. Like you guys, eh? You guys all have rights.
Kina, my name is Verna McGregor. I want to welcome everybody here to our territory. For those of you who've never come to a gathering before, we usually have the 4 sacred medicines: tobacco, cedar, sage, and sweetgrass. But when we're in a big crowd like this, what we do is we burn only the sage because it's considered women's medicine. It's very respectful of the women as a life giver, because when women are on their time, they're considered to be even more powerful. We bring in the next generation. We are the life givers. That is why we wear skirts for the women, because it's an honor of also bringing in the next generation and looking after the next generation. So that's why our meeting here today and all the work that you are doing is so important, because we're here for the next generation, for the children. If you do not feel comfortable in smudging, you don't have to. And why we smudge too as well is that we come together with good minds and good hearts. When we burn the sage, the tobacco, the smoke goes to the unseen world, so that our ancestors are here with us too to provide us with guidance. Miigwech kijemanedo, miigwech onje kakinaguch. Miigwech onje nigashkito jamaundo se gonshe nongom. We do kushine navagis. Shwen mishnon en navagis. Kinki de bendan kakinaguch. Shwen mishnon. Nindon de nes onje nongom, onje ya benoji shak. miigwech.
One of the things I want to say to all of us, to the commission, to the tribunal, to everybody here who has some interest in bringing them here today is this, that we try in all of our work to create a new space for us as Canadians. And we try to make it as far as is possible, sacred space that allows us to talk to each other in different ways, to be respectful, to listen with all of our being, the words that are said. Our hope, our real hope as human beings, as people, will be in a circle, our circle, together, all Canadians. And this week and weeks ahead, we're grappling with an issue that's so paramount to our Aboriginal people, but to us as Canadians. They're our kids, yours and mine, everybody here. They're not just our Aboriginal kids, they're ours together in this great country of ours. So I'm just so thankful that you came, and thankful to the commission and the tribunal. There's nothing, as far as I'm concerned, that is more important than the interest of our children. And it really starts here. Thank you.
Thank you.
I wanted to start by telling a story, and it's simply to illustrate one of the perspectives and the attitudes we had about our children where I grew up. The group of people, the Kwakwaka'wakw people that I belong to, and how they saw children, what the role of children was, what the purpose of children was, how valuable they were. So I wanted to tell a story about a ceremony that we have. It's not a long story, so bear with me. And it's called Hisu Gwila. That's a Kwakwala word, Hisu Gwila. And it simply says, enough time has elapsed. And what Hisu Gwila ceremony says is that in the old times, when a young child was born and they reached 10 moons, they were then deemed to be permanent members of the family, the immediate family and the human family. Before that, they were thought to be hovering between the spirit world and the mortal world. So at 10 moons, there was a huge celebration over this child. They convened the entire village. Sometimes other villages would come so that they could exercise and apply this Hisugwila to acknowledge this child's permanency and security in our ranks. All of the people that were gathered became witness to this transformative moment in a child's life. And we still do it at home today. We do it in what we call the big houses, because Gyukzi means big house, and they are our ceremonial houses. So we always conduct these ceremonies in these Gyukzi, these big houses, earthen floors, and there's a fire cackling. And it's really enchanting to be in those buildings when there are special ceremonies. And then we would invite the medicine people to come, people who had been trained, people who had been taught, and people who had learned to engage in this kind of medicine and Hisugwila and other ceremonials. Matriarchs were invited, and they were really important. They would be enlisted to mentor the young child, even though the young child can hardly comprehend anything. The mentors, the matriarchs would be talking to these little children about life and what's important, and to emote love to them. And then the keepers of the chants would come, and they would sing the chants that would create the sanctity in the space that we're conducting the ceremony, and it would become a spiritual experience. And then the speaker would rise and say, Qila kaza natmi, always at Qila kaza natmi. He would call all of the people engaged in the ceremony to proceed from behind a screen. And the screen was a metaphor for a separation between the spirit world and the mortal world. So all of these people would emerge from the screen and line up in the front, led by the father and mother cradling this little child. And then at that moment, one of the matriarchs would snip a piece of hair from the child and singe the hair in the abalone shell, and it was really important. Then a vase filled with healing water, we call it toilette, life-giving water, was brought out. And one of the matriarchs would wash the child, dry off the child. They'd have a cloth to dry off the child. And when that was done, they applied ochre to the face of the child. And at the same time that was happening to the child, other helpers would paint ochre on the faces of all of the throng of people who were present. And that was an invitation to those people, everybody in that room, to now become a part of this child's life, starting that moment. And all the while there was this chanting, incanting the supernatural, the creator, God, to be present and to bless the ceremony, bless the child, and to make sure that the child then forever was protected from harm and disease and other things. And then soon, everybody started in a procession to dance around the floor and celebrate this moment, celebrate this child, and in essence, make a commitment to be a part of this child's life forever. Oh, aye, la se, ya, ya, ha. Oh, aya, la sa, ya, ya, ha. Oh, aya, la sa, ya, ya, ha. Whoa, aye, la say, ya, hey, ya, tata, sama, sa, westa, sa, ya, hey, ya, oh, ya, la sa.
The imperial government in 1760, 1763, decided to intervene in North American affairs. And one of the ways it did was to take over direct responsibility for relations with First Nations people in what was then the British Empire, which of course was Canada and then the United States. That eventually in 1830 led to what I called the era of civilization, the idea that the British government had the responsibility for bringing tribal nations to a state of civilization, to a state of European-like development. So in 1848 or 49, they opened the first residential school.
Prior to my placement into St. Michael's Indian Residential School, I grew up in a little place called Guayastams. That's the name, Guayastams. And it's a midden, thousands of years old. Behind that midden is a forest, because we're a little cove, and in front of it was the ocean. And every road led to the beach, because we were ocean people. We harvested from the ocean, traveled by the ocean, and so the only real roads we had led to the waterfront. Our home was a tiny little house, one room, and as a little boy I could remember staring out. We had one window in the front, and the whole ocean cycle would drift by or swim by, or the birds would fly by. Reality for me was that I was watching creation, moving, flowing, changing, always impacting how I saw the world around me. And when you grow up in a place like that, you really do, after a while, develop a real sense of connection and a real sense of belonging. There were cultural events going on all the time, elders meeting all the time, thinking about the next gathering, thinking about the next celebration, thinking about life and death and marriage. It was a really rich culture that was vibrant and active.
That is the Reverend T.B.R. Westgate, D.D. He is the divine, of course. He's the secretary of the Indian and Eskimo Residential School Commission. The reason I like the picture is because it symbolizes what indeed the intentions were. Oftentimes, you find in the documents this idea that Europeans, but especially British Protestant Victorians, are parenting the world, that they have a responsibility to raise these people to a higher level of civilization. And indeed, that's exactly what the Reverend Westgate was all about. He was going to change the Aboriginal future in Canada by appropriating children, placing them in Anglican residential schools, and the same can be said for everybody else, and then producing someone who had been remade in the image of Victorian yeomanry, right? Victorian Canadians. This is Thomas Moore. He is a pretty good symbol of that past, right? He's weird looking. This is not European in any sense. Hair's long and it's braided, right? He's like some sort of prairie male partridge, all done up and all dressed up. But this is Thomas after tuition at the Regina Indian Industrial School. There he is, right? He's no longer wild anymore, right? He's a good, civilized young gentleman able to go out and, I don't know, work as a teller for the Bank of Canada or whatever it is, but he has been normalized. Notice the word, right? He's a normal Canadian. We know who he is. The nice thing about normalization, a process of normalization, of course, is that it produces citizens. And the great thing about citizens is they're predictable. They're loyal to the state. They obey the laws, and they're productive. And that's what Thomas has supposedly become, and the other students will as well. Aboriginal society will pass away. And that's all good, because indeed, we've rescued the children, and we've rescued their future.
I was telling somebody this morning that the authorities came in September every year in those early times. They would come in with a boat and scoop up all the kids. The parents didn't have any say. There was no discussion. Those kids had to go to St. Michael's Indian Residential School, Alert Bay. Can you imagine every September, and many of the Aboriginal communities every year, all of a sudden, there are no more children? I remember the day I ended up in St. Michael's School. My mother, my foster mother, Sally, was holding me by the hand, and I can't remember anything before that. But we were walking toward this big 3-story structure. My mother never said a word, didn't speak, didn't make any explanation. She just held me by the hand and led me to the school. We walked up those stairs. There's 15 stairs there to the front of the residential school. And there was a man standing there waiting for us. Obviously, he'd seen us coming. And my mother simply handed me over to him and turned around and left. Didn't say goodbye. Didn't look at me at all. And suddenly I was in this great big scary place. I didn't know a word of English. I didn't know what anybody said to me for the first few days. And for every instruction that we didn't understand and our wrong response, because we didn't understand this new language, was an indignity to ourselves. We'd be strapped or slapped on the ear, hit with a ruler, whatever it was. It was really brutal, those first early years in that school. I remember the first few nights I was there, I cried, and I cried, and I cried. And I couldn't cry out loud because you got punished for crying too. And I'd be under my covers. Sometimes you could hear other kids sobbing under their covers. Until I had no more tears. And then I fantasized about being back home, safe with my family, under loving care. But it was never to be. Lots of grants were made to fund these schools, the building of them and the maintenance of them. And these schools began to run deficits. And the churches would come back to the government and say, we don't have enough money to run the schools. Because they started by saying to the schools, we'll give you a per capita grant. You should have 100 students and we'll give you $50 a student or whatever it is. And then after that, off you go. Well, the churches would come back and say, well, that's not enough money. So they would begin a second round of lobbying to get more money. The per capita meant that there was a real stress on recruitment, that you had to get out there and you had to get students. So the churches were spending a good deal of time and effort in getting recruits to put them in the schools. There were some accusations of vaguely unethical tactics, kidnapping children and things like this. In my research, I found accusations of that. I found no proof of it, right? Just people saying they go and they take children and put them in the schools. Certainly, one of the Anglican bishops in northern British Columbia complained that he was rather worried that the children they were taking into school just to keep the head count up were children who never should have been in school. They were not well enough to go to the schools. It sort of comes to a crisis in 1907, the funding business. And it comes to a crisis because one of the impacts of overcrowding is finally recognized and publicized. Dr. Bryce was the department's medical officer. He did a survey, and what was revealed was a pretty horrifying situation in terms of the health of the students.
Dr. Bryce conducted his survey exactly 100 years before this complaint was filed, when Canada was only 40 years old. He was appalled to discover that 24% of the children were dying of tuberculosis and that they were living in filthy conditions. Dr. Bryce wrote a report on the situation, but Mr. Duncan Campbell Scott of the Indian Department ensured that the report was buried and that the public and organizations that treated tuberculosis did not find out about conditions in the schools. Eventually, Dr. Bryce was informed that his services were no longer required, so he finally sold his report on his own for the price of 35 cents. Thank you, Dr. Bryce, for caring so much about the children.
I also quote one of the Toronto lawyers in the text. He wrote to the Anglican Church, having seen the Bryce report and having become familiar through his own research, and made the following sort of scary pronouncement. He told them that they were within an uncomfortable nearness of a charge of manslaughter by taking these children into the schools.
And on a daily basis, all of the activities of the children were under constant surveillance. I'm thinking back on my own experience in St. Michael's Indian Residential School now. There is nothing I did. There wasn't a breath that I took where a supervisor wasn't close by monitoring where you were and what you were doing. You could be eating, sleeping, praying, working, bathing. All of it was subject to monitoring and timetables and rules. And you have to remember that during those early times, they targeted little children as young as 3 years old. We were segregated from our siblings. My sister, because of her gender, lived on one side of the building, and I barely got to speak to her. If I was caught waving to my sister, that was a no-no. And so we lost the ability of all of these relationships with our families and others, friends, and being segregated all the time. I had no social skills around young women or girls. None at all. So shy. I thought, I don't know how to relate to other people. There were so many skills we lost. And of course, the language was absolutely forbidden in some places. Public strips and general searches were commonplace. And they were thinly veiled I think they were thinly veiled for practices of sexual assault. Withholding letters and presents from family was common. Children were sometimes locked in closets and cages. In St. Michael's Residential School, when I was little, you entered the back of the building down to the playroom. There was a small space, wasn't very big. And they had a chicken coop built there. And it was about that high. And if you were misbehaving, they threw you in there. And you had to have bread and water for the day.
Corporal punishment. Children's faces are slapped, hit on the head, struck across the nose, causing nosebleeds. One teacher said a boy in her classroom had a swollen face for 2 days from being slapped. Another teacher reported that one of her pupils was slapped in the face because he couldn't read the small print in the hymn books. One of my grade 8 boys was slapped on the head until he was pale. He staggered, complained of feeling dizzy, and his nose bled profusely. This was witnessed by most of the schoolboys. He fainted 5 days later in prayers and again in my classroom. And when you read the files, and I read so many of them, there was a sort of buzz about the files, a sort of background noise of violence, that the level was pretty constant, that slapping people in the face and the sorts of things this teacher reported was pretty common, ordinary, everyday sort of activity. In my school, I got punished because I had done something my parents would not agree with. I'd lied or stole something. In these schools, in many times, children were, way too many times, children were punished for who their parents were. We must beat it out of you. We must kill the Indian and the child. You must not be like your parents.
I graduated from grade 12 in that school. Before I'd gotten to grade 12, I started drinking when I was 14. And I was already a full-blown alcoholic by the time I graduated. So anyway, graduation day came, and then we went on a party. I must, when it became habit, just blacked out that night. And it was 2 or 3 days before I finally realized school's done. I'm going to go return to this residential school, get my belongings, and leave forever. So I didn't know what happened during that lapse of time. But finally, I went back to school, and I walked up those stairs that I mentioned. And the principal was waiting there. And he and I had a lot of fights, a lot of differences. He stripped me down in front of the entire school one time, the boys' side, because he caught me smoking. He told me to bend over this, and I was a teenager by then, chair. So I did. He said, no, drop your drawers. And I was so humiliated. Remembered it forever. But anyway, this same man, as I walked back from my party, my celebration, was on the top of the stairway, and he said, can I talk to you for a moment, Bob? And I knew that I would never have to account to him anymore. I said, of course. And I went to his office. In essence, he said this: you and I have had a lot of problems. For what it's worth, I think you're going to be all right. I didn't understand that. This guy gave me such a hard time, and he's saying that now at the end of his time. So I said, thank you, sir. And I got up, went and got my meager belongings in a little suitcase, came out from my dorm, and I stood at the top of those stairs, those, for me, infamous stairs, and suddenly realized the futility of my life. I had no idea what I would do once I started taking those steps down, or where I would live even. And here's here was a time when young people should dream dreams, think of the future, and think about the possibilities. And here I was just a broken human being.
The post-war period for Aboriginal people anyway starts with a movement by the department towards this idea of integration, that Aboriginal people should be integrated with the general population. Aboriginal children, they're now going to be educated along with non-Aboriginal children in state schools, and Indian Affairs then has the green light to increasingly disestablish residential schools, close the system, and move children into day schools. It takes 40 years, approximately, to get the system closed down. The problem is there are children and families who, rightly or wrongly, are judged by the social workers as being incapable of properly taking care of their children. So there is this segue from residential schools as educational institutions to residential schools as child welfare institutions, and then as they close, children are found, children who cannot be integrated successfully in with respect to their families, and local social welfare services are found to be wards of the Children's Aid Society across the country in large numbers. In 1968, the Minister Jean Chrétien wrote to G.R. Baldwin, a member of Parliament, "It has been found that for the average Indian child, remaining a member of the family unit can be more beneficial than the best residential school care." This really puts a period to it, I think, because if you remember, we start with the exact opposite assumption. The opposite assumption that the system is obviously based on is that, as regrettable as it may be, the Aboriginal family needs to be disrupted by the removal of children to an institution dominated by white people and white ideologies and white ontologies. We finally got to the point from the mouth of the minister himself, the exact opposite. It's best for children to be raised by their own parents in as healthy circumstances as possible, and that is what the future should be for our relationship in education. It is concluded.
So along came the settlement agreement. That was a really important milestone. The Prime Minister's apology was really important. Aboriginal people, by the way, across the country, some places are still very angry at the Prime Minister. They still think the apology has no value. But I'm telling you that that apology was incremental to everything that we've been doing lately. That at some point, at the highest level of our country, the Prime Minister, he made an apology. I never thought in my lifetime that a Prime Minister would apologize to me. So I was in the House of Commons when he made this apology.
Thank you very much. Mr. Speaker, I stand before you today to
And I couldn't hear too well,
of Indian residential schools.
but I heard the words,
The treatment of children
"I'm
in
sorry,"
residential schools.
and I wept. I did that in the House of Commons.
We now recognize that it was wrong to separate children from rich and vibrant cultures and traditions, that it created a void in many lives and communities, and we apologize for having done this. We now recognize that in separating children from their families, we undermine the ability of many to adequately parent their own children and sow the seeds for generations to follow. And we apologize for having done this.
That was so important. And I hear from my peers, my colleagues now, former survivors, starting to examine this apology in a new light and see new ways and how it's impacted their thinking and their lives. And that's why I'm convinced that reconciliation is a choice that we have to make. that it doesn't need to be ancient time. In the ancient time, reconciliation was a spiritual imperative every day. You could hear it in songs or the dances or the protocol or different individual acts of seeking balance and harmony. The old ways, and that's how we slowly started to convince other survivors that reconciliation is important, by the way, because we talked to enough elders who said, yeah, reconciliation had to be a way of life, or we would destroy ourselves. Somehow we had to reconcile, find ways to reconcile, to get along, to live with each other, coexist. We can't make the same mistake twice.
Please be seated.
Good morning, everyone. It is with great honor and privilege that the panel members and I sit before you to hear the parties' closing arguments in this important case. Let's begin with the first party to present its closing arguments. It's the Commission, and the first speaker is Mr. Philippe Dufresne. Thank you.
For all its complexities, and there are many, for all its exhibits, all the documentation, all the testimony, this case, in our view, has asked a single fundamental question, and is this: are First Nations children on reserve entitled to the same safety and well-being as all other children in Canada? We say that they are, and that as a result, they are entitled to at least the same level of child welfare services as those provided to all other children in Canada.
My basic premise with respect to how to look at this case and to understand it is, first and foremost, it's a case for substantive equality, which at the very least includes treating First Nations children on reserve at least as well as other Canadian children. But it also entails more because it's substantive equality, and it's going to entail some provision of services that recognize the unique history, characteristics, and needs of First Nations. And it's difficult to imagine a stronger case for substantive equality when the unequal, in this case First Nations, trace their lack of equality to the historic treatment of them by the Government of Canada, going back to colonialism, the school system, and to the current day in not even receiving the same benefits as other Canadians. I don't believe that there's any evidence before you to suggest that the services are in any sense good enough to overcome the disadvantage. And in my submission, the outcomes alone demonstrate that they couldn't possibly be good enough.
I'll read a passage in Dr. Malloy's book. There's one image in particular that kind of haunted me. The condition of one little girl found in the infirmary is pitiable indeed. She lies curled up in a bed that is filthy, in a room that's untidy, dirty, dilapidated, in the northwest corner of the building, with no provision of balcony, sunshine, or fresh air. Both sides of her neck and chest are swollen, and 5 foul ulcers are discovered when we lift the bandages. This gives her pain. And her tears from fear of being touched intensifies. The picture of her misery. This little girl is somebody's daughter. We need to think about the kids that are removed currently in the same kind of empathetic state, because they will have fears, they will have pain, they'll have feelings, and we need to be mindful of that those are, they're human beings.
This case is so important. It's of course vitally important in relation to child welfare, which is important on its own, clearly, but there's obviously a precedent-setting nature of the case, because as luck would have it, or perhaps strategy, a lot, if not all, of the federal programs, and this gets beyond this case, but a lot of the programs that are out there, education, even social assistance, health, and so forth and so on, all these programs that are delivered to and for First Nations are basically on the same model. So that if there's a finding, say in this particular program, that basically there's the program is beyond scrutiny under the Canadian Human Rights Act, that could well, not necessarily, because each program is a little bit different, but it could well lead to the situation where all these programs are immune from the Canadian Human Rights Act, which really would be shocking result. And as was mentioned yesterday, even to the point where it could lead to the shocking situation where the human rights statute itself could be subject to a Section 15 challenge under the Charter, because the Human Rights Act itself could be found to be discriminatory because of the effect of immunizing all these programs relating to First Nations. So that would be quite an amazing situation, and hopefully to be avoided at all costs.
While you've been told that there's been clear and convincing evidence of discrimination, we would submit that's simply not supported by the evidence you have heard over the past several weeks. This is what we want to speak to you about in greater detail today: the lack of an evidentiary foundation to support many of the accusations made, that there are false assumptions, for example, regarding the percentage of children in care nationally, when in fact they're justified and endorsed by the participants in the program and objective observers such as the Auditor General of Canada. That there is no real money for prevention under EPFA when there has been significant investments and increased budgets. The development of EPFA and the approach that's taken is not some policy that's thought up in the afternoon by ignorant bureaucrats over in Ottawa in an afternoon. It's developed through detailed consultations, discussions with stakeholders, with First Nations representatives, with communities, with the provincial representatives, with the federal government representatives. There's even been consultation with advocacy organizations like the Caring Society in the past. They can't dispute it. They've pointed out their involvement. They can't now say that the government has not offered and given them an opportunity to provide input and consultation and views. Sometimes the decisions reached by governments aren't necessarily the exactly mirror the positions being advanced by stakeholders or by advocacy organizations. This is part of what happens in a democratic society.
You're aware that in 2012, the people who work in the department made a case for a cabinet and then Treasury Board approval. And they presented a number of options, 3. And in those options, they specifically referred to deficiencies with respect to the current level of funding. If the employees make the best possible case that there's underfunding, and the fact is that the political process doesn't allow that funding to occur, it doesn't really make any difference in terms of this case, does it?
Well, the government has many programs, and they're important to First Nations children and their families, and to other members of other Canadians, because the government of Canada does represent all Canadians. It's reasonable for, I think, given that the benefits that First Nations receive, it's reasonable for the government to say, look, we cannot give you all the money you want, when you want, how you want. We'd love to, but we have other priorities that we have to address. What has happened is that you're taking a situation which is tried to be built on cooperation and consensus, and it's becoming very adversarial. And in this context, it's particularly more unfortunately troubling because, it's the agencies and the communities themselves, while we can appreciate they're represented to some extent through the First Nation, they're not the ones that are directly here. We're not dealing with a complaint from a given agency who says, look, we really have suffered something here. We haven't had those agencies or communities directly here as the complainant party. We hear that they're being represented by the AFN and by the Caring Society. I can see, envision, given the AFN's mandate, how that is, but it's a little harder to put that together with the Caring Society. But nonetheless, we don't have these complainants here directly giving the evidence that would establish that nexus.
I've often wondered, what's it going to take to change things? Native people, I think, have a completely different perspective on obligations and responsibilities and justice. So they're not going to write a contract or enter into a treaty on the basis that I'm going to use all the loopholes I can to get out of it and I'm still right. They have the perspective is, more mindful of your partner and how his or her reaction will be, or their reaction will be to how you act.
We, and most notably you panel members, don't have any evidence to say that children are being taken out of the home in unnecessary situations. In fact, what we have is a submission from the other parties asking you to draw an assumption in the absence of evidence. They're asking you to draw an assumption based on conjecture, and that is not sound in law or principle. We heard extensive testimony from Dr. Blackstock throughout the hearing. We do not dispute her passion or her conviction and commitment for child welfare or her desire to reach better outcomes for First Nation children on reserve. And I do not mean this in any way to be any slight. What I am just simply pointing out for the tribunal members is that much of her evidence was not based on direct knowledge of how either federal funding for child welfare on reserves works or how provinces fund their programs. It's clear that it's been a long time since she had any direct experience working in a First Nations Child and Family Service Agency, such that she can speak authoritatively as to what's happening in that respect today. What we would say and urge you is to think seriously about considering whether this is the right forum or place for this type of claim to be addressed.
Our children are our most precious resource, and we can't have them being taken away, put in non-native families where their languages aren't taught, culture is not taught, the transmission of the traditional knowledge and cultural expressions, their whole essence of being Aboriginal is no longer available to them. This program, if run properly and prevention services are made available to First Nations at comparable levels, or even, because the need is higher, at even more of a higher level, it can begin to reverse the intergenerational impacts of residential schools. This is one program, in addition to education, that can make a difference to future generations of First Nations peoples. And that's what's at stake here. By continuing taking First Nation people away from their families and putting them out of their homes, they're beginning to miss out. And we think that it's important that you consider the impacts to all the First Nation children that are out there. Not only to the First Nation child that's being apprehended, but as they say in residential school, the parents left at home, but also their siblings. There is real harm being done to First Nations people, and that harm has to stop.
This concludes the hearing in this case. First, we would like to thank all the parties and the interveners and the witnesses for their participation in this hearing. And on this note, we will adjourn. Thank you very much.
Order, please.
The last day of hearings was October 24, 2014. The tribunal members examined the 72 days of testimony and the documents put into evidence. In June of 2015, the tribunal released its decision on the retaliation aspect of the complaint and found that the government did retaliate against Cindy Blackstock and ordered them to compensate her for a total of $20,000. January 26, 2016, 9 years after the complaint was filed, the tribunal released its ruling on government support for First Nations child welfare services.
It felt unreal in some ways because it's been 9 years. And before I read it, I felt joyful, relieved, a big relief, and a bit nervous. So I didn't know what was in those pages. Yeah. But as I opened it up and I saw one of the first things they did was acknowledge the residential school survivors, I thought this is going to be a good day for kids. And I kept reading it, and it was so wonderful to see someone believe the children's story. They heard it, they felt it, and they knew how wrong it was, and they were going to make it right.
This is a complete victory for children. It strips away any sensibility that First Nations children are being treated fairly by the Government of Canada today. And I want to dedicate this decision to all of the First Nations children who for years and for decades have been denied an equal opportunity to live the life they wish to have had. And sadly, too often were judged by a Canadian public who didn't know any better as if they got more. And I want to dedicate this decision to the thousands of non-Aboriginal children who have written letters to the Prime Ministers over this last 9 years. You see, children may not be experts in politics, but they are experts in love and fairness. And when non-Aboriginal and First Nations children see something that's wrong, they want to do something about it.
Without question, we welcome the decision today. And at this time in our country's history, discrimination in any form is entirely unacceptable.
If a child can't be kept at home because there's not a fire extinguisher in the house, we'll get a fire extinguisher in the house, not take the kid away.
Wow, fantastic. What a day in history for First Nation children. What a day.
Overwhelmed, ecstatic. Just happy that we can now do things for the kids that we've been wanting to do for the last 20 plus years. Justice is done.
Thank you, Sydney, for all that you've done for the children.
What does today mean, not just for the kids, but considering how hard the government fought against you on this?
Yes, I went through retaliation by the government. Yes, I was put under surveillance. But that's my job, not just as a social worker, but as a person. When you see something happening that's wrong for kids, it's your job to stand up and make sure that you do everything in your power to make sure they have a proper childhood. So when I read the decision, the first thought in my brain was, I thought, it's all been worth it. It's all been worth it. But I need to see things happen for the kids. Change isn't in a decision, it's in their childhoods. And it'll all be worth it if these kids finally get a chance. And we finally do right by them. God help us, let's do that much.